We'll do like this. We'll fix it on time for final hearing.
Final hearing of what?
May I please, Your Lordship? Lordship, I beg to mention item number 15. Your Lordship, I seek some more time to file affidavit, Your Lordship, in this case.
You are for?
I'm for the petitioner, Your Lordship. 3 weeks, Your
For the
Lordship.
responding Lordship.
Have you filed your counter?
Not yet, Lordship. We need some more time, Lordship.
Your Lordship, after filing of the affidavit in opposition, we have filed our rejoinder. In the meantime, there was some records to be brought before the Honorable Court, Your Lordship. So we are trying to bring those through filing of affidavit, Your Lordship, additional affidavit. So I'm bringing some more time, Your Lordship.
Inquiry report?
Yes, Your Lordship. The court-martial proceeding.
Yes. On pre-made by how long?
3 weeks, Your Lordship.
3 weeks. Yes. On pre-made by petitioner? This is matter up to 3 weeks.
Oblige, Your Lordship.
Your Lordship, I beg to mention item number 10. Similar matters pending before the division bench, Your Lordship.
Yes. You are for?
For the petitioner, Your Lordship.
Yeah. Who's for these respondent?
Ravi Guru.
For the state respondents, Mr. Bhattacharya. Sir, Mr. R. Guru, Mr. Councilman.
The counsel for the petitioner has submitted that similar matter is pending adjudication before the division bench and has accordingly sought for accommodation in this matter. On pre-made, the same is allowed. This is matter after 3 weeks.
Much obliged, Your Lordship.
Lordship, beg to mention item number 16 jointly since Sir Mujika is not there.
He's out of station, Lordship.
On pre-made by the parties, this is matter of the 3 weeks.
Sure, Lordship.
Lordship, I beg to mention item 20 and 21. Bail matters, Lordship. Senior counsel is not present physically, Your Lordship. So can he on Thursday, Your Lordship?
But
Mr. Mujika is out of
bail
station
matter, what is required here?
for hearing, Your
Lordship
Lordship.
has actually asked both parties to bring forth relevant judgments with regard to section 41A, Lordship. So, Lordship, this matter needs to be heard at length.
I'm praying for Thursday, Your Lordship.
Lordship, I'll not be available Thursday, Friday, Lordship.
1 week
Next week, Lordship.
on pre-made by the petitioner. This is matter after 1 week.
Much obliged, Lordship.
Early, Lordship.
2021.
Lordship.
Daily cost list, item number 1.
Yes, Mr.
Mr. Mujika informed me that item he will not be there in this session. So item 13 of the hearing.
But he is here.
But are there online minutes?
So,
I'll ask you next week minutes. When I'm there, minutes.
on pre-made by the respondent. This is matter after 2 weeks.
2 weeks.
So 2 weeks.
May please, Your Lordship. He's appearing for the other side. Well, this is an application under section 482. Here, my lord, a complaint has been filed against my company, and these 3 are the directors of the company. Now, my lord, complaint has been filed for contravention of offences under the Drugs and Cosmetics Act. Well, my case here is I am the director of the company. I am not involved in the day-to-day functioning of the company as much as it comes to the manufacture of the drug. Now, my lord, there are judgments, many judgments in this context. Now, my lord, in fact, I had a compilation with me because I want to argue this on this particular point. Apart from that, also on the ground that, my lord, these people are domicile of Gujarat. Now, even though the petition has been filed by the government, compliance of section 202 CRPC is absolutely necessary. Now, what the trial court has done is, without any application of mine, very categorically on receipt of the complaint, straight away issued process. So that is the case I have, my lord. But today, if I be able to...
But process is what? Process is to compel you to appear.
Absolutely, my lord. But
Then
even for that... my
you
lord,
could appear and then state your case.
Correct, my lord. But then even in issuance of process, my lord, some application of mine has to be there because it curtails my liberty, my lord. I have to come all the way from Gujarat and appear in Shillong. And my lord, there is a...
I think there is no, you see, as far as distance is concerned,
My lord.
I don't think we are on it now. Anyone or anything can be done through the virtual mode.
My lord.
If
Lord.
there's a summon, or rather if there's a warrant for your arrest, that's a different thing.
That's altogether different, but my lord, my case is not only that, my lord, apart from that, there are some technicalities which have not been adhered to. Number one being that, my lord, the concept of vicarious liability in criminal jurisprudence is totally alien. But I cannot be fastened with the guilt when I have not been involved in the manufacture of the drug. There are a plethora of judgments which I want to place before this honorable.
But I'll appear for respondents, my lord. I'll accept notice, my lord. My lord, this is a case where the substandard drugs have been supplied to the government hospital. And that is why the drug controller has come into seat, my lord, and this sees the drugs and finds prosecution case. But I have instruction, my lord. My lord, certain facts may be necessary, my lord. So, lordship, permit me to file an affidavit, my lord, in this matter. 3 weeks time.
How long?
3 weeks time.
Mr. KCH Gautam, legal counsel for the petitioner, has submitted that this is an application under section 482 with prayer to quash the proceedings. What is the reference?
Well, the offence under section 18A
Within
is there the cost title?
before which court?
Before the court of the judicial magistrate.
CR case number 254. Room to call. Proceedings in CR case number 254 S capital S of 2019 before the court of the Judicial Magistrate First Class Shillong. Dr. Inmuzega Leonard DSGI has accepted notice on behalf of the respondent and has also submitted that he may be allowed to seek instructions before the matter is heard. It is also the prayer of the Leonard DSGI that the respondent may be allowed to file an affidavit stating certain facts therein which are related to the subject matter of this petition. As prayed for, in view of the fact that notice has been, the respondent has entered appearance, no notice is required. No further notice is required to be issued.
I'm also pressing for stay, my lord. The reason being, my lord, in this case, administrative action has already been taken against me, my lord. My license was suspended for 1 day. Administrative action as completed under the rules have already been taken. Even after that, my lord, this prosecution has been, this case has been filed against me. If it is for 3 weeks, my lord, then because the matter is fixed, I think in the fact end of August, I will not press today, but perhaps, my lord, if the matter cannot be taken up after 3 weeks, then perhaps, my lord, I'll have to seek indulgence from it.
Fine, then let the matter come up. Hopefully, we'll try to dispose it off at that point in time. This is matter of the 3 weeks.
Item number 2.
I'm praying for a further 1 week's time. Filing my rejoinder.
All the respondents have filed their counter?
State respondents.
Only the state respondents.
State respondents.
Mr. M.L. Nompiol, counsel for the petitioner, has sought further 1 week's time to file the rejoinder to the counter affidavit filed by the state respondent. Prayers allowed. Let the said rejoinder be filed within the next date fixed. List this matter for 2 weeks.
Item number 3.
This is the response.
Madam, number 3, I am appearing for the petitioner, madam. Madam, we have just on Friday we have received an affidavit filed by the respondent, by the private respondent, madam.
Yes.
So, madam, I am praying for some time, madam, to go through the affidavit, madam, and file a reply to that, if necessary, madam.
May I submit, my lord?
Yes.
With the leave of the court, my lord, here in this case I have been engaged, my lord, wherein I have gone through the criminal petition for quashing been filed. I find, strangely, my lord, certain documents that has been annexed with this before this Honorable High Court, which is a judicial proceeding as for the purpose of Section 340 of the CRPC. These are all false documents. And apart from that, on the basis of false documents, my lord, even government money has been siphoned off. So for that purpose, to take judicial notice of these aforesaid facts, we are preferring a petition under 340 also. My lord will kindly grant me the leave to file that particular petition under 340, my lord. And fixing it, my lord, if it is convenient for the other side, on 18, my lord, 18th of August.
What was filed?
Madam, on this prayer, madam, let the matter be heard, the petition which we have filed, madam. If something comes out in the process of hearing, madam, in the course of hearing, Lordship may grant any kind of liberty, madam. But which documents they are saying that these are false document, madam, they should point out first in the course of hearing, madam, which are the documents, which are false documents, madam.
My lord,
I'm only praying for 2 weeks time today, madam.
my lord, my prayer is very limited, my lord. In a judicial proceeding, my lord, wherein the one person says, my lord, a document has been annexed with this and been relied by the petitioner, and which is a non-existing document in the department. So I don't have this to take permission from this. It is my duty to point out any offence has been committed during the proceeding of a judicial proceeding in the court. 195 comes as a bar. I cannot go and lodge an independent affair. This court will be the complainant. The registry will file this, and this will be a subject matter in during hearing also. Let me bring on record what is the forgery they have committed, my lord. They cannot stop me from filing any petition, my lord.
What about the role of the state?
My lord?
What about the role of the state?
In fact, my lord, I am only submitting when the Lordship will hear the matter, my lord. At the time of hearing, if they can point out and if they can satisfy your Lordship that some certain document is forged or false, my lord, the Lordship can grant permission that point of time, my lord. But my lord, in my humble submission, today they just served a copy of the affidavit on Friday, my lord, and now without examining the matter, no liberty can be given. No legal liberty can be given.
But may it please your Lordship. Lordship, in fact, last time, the last hearing, I have made a submission, your Lordship, that certain document appears to be as per the investigation, your Lordship, not genuine, your Lordship. That was my submission last.
So it's incumbent upon you to file a status report in that.
Lordship, if a date is fixed, then I'll requisition the progress of the investigation as well as the case there, your Lordship.
So we'll take it up as and when.
In the meantime, my lord, if we file that particular 340 petition, they have the right to reply to that, my lord. In the meantime, valuable time of the court will not be wasted, my lord.
Even in the, you see, if you stand on the same footing as far as the state is concerned,
yes,
then if this state has taken the initiative, it's not required for you to.
I leave it to the court. Even the court had the suo motu power to.
Exactly.
Yeah, absolutely.
As and when the matter is taken out.
Absolutely, my lord. We will, my lord.
And both parties, all the parties are heard.
Yes, well, let it be.
So as of now, what we'll do is we'll allow the petitioner to appear on next date to be heard. And as far as who has filed the affidavit, you.
We have filed it.
The private respondent,
The complainant.
What is the content of the affidavit?
Affidavit is this, my lord. Whatever they have stated. My lord, this is with regard to a Calcutta case being registered, and this is with regard to a case being registered in under Meghalaya in Shillong, within the jurisdiction of Meghalaya, my lord. Now their case has been like it's a continuous offer, it's a same transaction, NSS, no two affairs, no case has been made out. These are general grounds. In our affidavit, we have taken a specific plea that my brother's signature has been forged, on the basis of which bill has been submitted by the company. On the basis of forged document, they have taken a siphon of government money. This is my case. Altogether different incident, my lord. And with this regard to that factual matrix that these are false documents, that is also been highlighted, my lord.
Fine.
18, my lord, if your lordships, other side is also agreeable to it. 18.8, my lord. It's been Wednesday.
No, 18 is Tuesday.
18.8.
We'll take it up on 17th then.
17th, my lord. 17 is closed, my lord. I
No,
see it red.
that is July.
That is
July. Oh.
I was also looking at that.
That is the August calendar.
Yes, my lord. There has been a matter before another court been fixed on 17, my lord. May I pray it, my lord, any other date, my lord?
Then we can go to 21.
You choose the date.
21, my lord.
That's Monday.
Monday, my lord. Let it be on 21.
The
21.
respondent number 2 has filed an affidavit to which the learned counsel for the petitioner, learned senior counsel appearing for the petitioner, has submitted that he may be allowed to peruse the same and to respond accordingly in course of hearing. As prayed for by the parties, list this matter on 21.
Not if necessary for an affidavit also. Because what they are trying to do,
Yes,
they are
right.
trying to bring new material facts on record.
The
So if necessary, only that
learned senior counsel for the petitioner has also submitted that if so instructed, he may be allowed to file an affidavit in response to the affidavit filed by the respondent number 2. As prayed for, list this matter on 21st.
21st.
Oblige, Lord.
Oblige.
Item number 4.
Lordship, 4 to 8 are connected matters, Lordship. So, in 4 of the matters we've received instructions, 1 is pending, Lordship.
Have you filed a counter?
No, Lordship, because we're waiting for the instructions of the last matter also, Lordship. Because we cannot go on a separate ground, Lordship. So,
All the respondents are in attendance.
Yes, Your Lordship.
Lordship, state.
Your Lordship, in this case, Your Lordship, I found a miscase. One pleading, Your Lordship. One pleading, Your Lordship.
Completed.
Yes, the applicant.
Who are you?
The applicant before Your Lordship belongs to Sounding Plan, Your Lordship. As far as the case of the petition is concerned, Your Lordship, because of the ongoing title suit disputes, no development can be carried out in the suit, Your Lordship. And the Sounding Plan is one of the parties in the title suit, Your Lordship. For that reason, they are the necessary party in the case, Your Lordship.
You should have arrayed them as necessary
Yes,
parties.
they have made only Im Yong as a
Lordship,
party.
I've just received the copy of the application, Your Lordship. I'd like to examine. If need be, I would like to file my objection, Your Lordship. 2 weeks may be granted, Your Lordship.
Mr. Arujao, the counsel, has submitted that a miscase has been filed with a prayer for impleadment of the applicant therein, who is a party. The title suit is still pending.
Pending, Your Lordship.
Who is a party in the original title suit involving or rather connected with the subject matter in this petition. In response, the learned counsel for the petitioner has submitted that he has received the copy of this said application only today and would require some time to seek instruction to respond to the same. Ms. Njishela, learned senior GA, has submitted that the counter affidavit on behalf of the state respondent could not be filed today and has sought for some time for the same to be filed. Similarly, all the other respondents have also seek time to file their counter affidavit. On preempt, list this matter up to 3 weeks.
Much obliged, Lordship.
Obliged, sir.
Item number 9.
But we have filed an affidavit, my lord, bringing into the records. That's one number 6. It was pending for appearance of son number 6, my lord.
So,
As well as filed no affidavit by the others.
Mr. Philemon Nombre has entered appearance on behalf of the respondent 6. Has any counter affidavit been filed?
No, we'll bring for some more time.
The respondents are to file their counter affidavit within the next date fix. List this matter after 3 weeks.
There will be 2 weeks, my lord. There's an interim application also, my lord.
2 weeks.
Item number 11.
Yes. Who's appearing for the state? Yes, Ms. Sheila, tell me. Mr. Sen Gupta, Mr. Abraham is supposed to be there.
Lordship, Lordship, I just received information that Mr. Sengupta is keeping unwell. He's at the hospital as of the moment, Lordship. He's handling the matter. So let it come after just 1 week, Lordship.
2016 matter.
Lordship. I apologize, Lordship.
It is submitted at the bar that Mr. S. N. Gupta, learned additional senior GA, who is conducting this matter on behalf of the state respondent, is not keeping well and is under treatment in the hospital.
It's just for checkup, Lordship. He's not admitted, just for checkup. Lordship.
He's not keeping well and as such could not appear for this court today. Accommodation thereof is prayed for in this matter. On preempt, list this matter up to 1 week.
My apologies, Lordship. Much obliged.
Item number 12.
Yes, Mr. Angelica?
But that is regarding the merchant issue.
You just have to.
That they also is there, my lord.
He's coming, but I'm ready, Lordship. Day also is coming. He just went to go. But meantime,
So you just brief the court on what is your case? Have you finished? Have you concluded your argument?
Yes.
You have concluded. Only the reply.
Yes.
So what is the case about? Tell me.
The case is that, my lord. I will repeat in short, my lord.
Yes.
In 1964, one Junction Momin was the Nokma.
Yes.
After his death, after death of his first wife, they have given a substitute wife. That substitute wife, after some time, he is deserted the Junction Momi and fled with another person, my lord. In the meanwhile, my lord, these clan people, Nankra clan people, has given another substitute wife. That is my parents, the Rane and Marak, my lord. In the meanwhile, what happened, my lord? This respondent number 4 making another group, my lord. They are going to the district council and they are pressing the matter that his wife, substitute wife, is fled away. So, clan people selected Alipshan Marak and his wife, Mene Marak, claim that one, that clan people select us as he is no more Nokma, so give us the appointment. According to that, my lord, he was appointed as a Dokma, which has been challenged by the Alipshan Momin and his wife Rane Marak in the district council court. Then and there what happened, because they are running only Nukbashik for 1 to 3 months only, then and there it is fine, it is state, and subsequently they have given order in my favor. That's in favor of the Jongshan Momin and his wife Rane Marak. They have challenged, both of them challenged that order. After challenging this order, my lord, it was set aside and given in favor of me on 3rd September 1978, my lord.
3rd September?
3rd September 1978, my lord.
Where is that? The order is here.
Order 3rd September, that order is not here. That is the initial this thing, my lord. Additional. In additional affidavit. I'll go for brief case, fact of the case, my lord. After that, what happened, man? That order has been challenged by the Alipshan Marak and Mene Marak before the Honorable High Court, Guwahati High Court, my lord.
Okay.
And the case was registered by the CRP number 936 of 1982. Subsequently, what happened, my lord? 5th March 1992, they have withdrawn the writ petition. Being withdrawn, the case was dismissed on withdrawals. That is in the main writ petition, my lord. Case number 21.
So that has gone in your favor?
Yes. It has been cancelled. And since then, the Jongshan Momin and the Rane Marak was continued as a Nokma till 2000, my lord.
Yes.
After the death of Rane Marak, then another is coming into the pictures. That is Suranankra Marak and Suranankra Marak and Shimran Momin, my lord. That order has been challenged by the Alipshan and his wife while case was pending. They have expired, my lord. So the present respondent number 4 pursue the case, my lord. Then what happened? Then White Order 23/12/2003, my lord, in my additional affidavit, it has given in favor of respondent number 4, my lord. Thereafter, number of court cases is going on, my lord. And lastly, what happened, my lord? Against this order, my lord, 23rd December 2003, which has been given in favor of respondent number 4, it had been challenged, my lord, by this Suranankra Marak and Shimran Momin, my lord. Court has set aside this order and remand back to District Council, my lord. White order on WPC number 247 SS 2004. White order 21st March 2006. It has been referred back to District Council for de novo trial, my lord. After that, what happened, my lord? It has gone to the District Council. District Council passed an order on 1st March 2013, my lord. That in this order, my lord, only they have given that parties are present, heard their learned counsel submission, judgment and order is pronounced in an open court, which is prepared in a separate sheet, my lord. Whereas no order has been passed in this case, my lord. After that, what happened, my lord? We have make an application. If you pass any judgment, give us this judgment. On 8 June 2013, my lord. They could not provide, my lord, to us. Again, we have filed another application to the Secretary to the Executive Committee, GSSDC, Tura, my lord, dated 4th February 2013. But they have not provided any document, my lord. No judgment has been pronounced. Thereafter, as there is no order has been passed and case is pending, my lord, we come to Honorable High Court, my lord, by filing a writ petition. Filing a writ petition before this Honorable High Court, my lord. Then Honorable High Court has set aside this order and remand back to District Council, my lord. That is in the writ petition, my lord. In page number. After that, what happened, my lord? When it is referred back to the District Council, my lord, District Council, without serving any notice to us or taking any evidence, simply accumulate all this document and pass an order on 16 January 2016, my lord.
So that is the impugn order?
That is the impugn order, my lord.
Which?
Page is 34, my lord. Now, dated is 16 December 2016, my lord.
Yes, a moment.
Yeah. Then I will go for the last.
Just a moment. This is 15 December 2016. Okay. Yes.
Then type copy, my lord, that impugn order. Just I read. Page number 165, last page, my lord.
165?
Yes, 165, para 34.
Yes.
Shall I read out, my lord? 34.
Please.
I therefore, considering all the relevant fact and find that Srimati Medalin and Marak is the direct descendant last recorded female King Lokma. That is wrong, my lord. Last recorded Lokma is the Chora Nankra Marak and Shimran Momin, my lord. That is late Srimati Mensayan Marak, and her close relationship with late Jamse Marak has not been controverted in the entire proceeding taken up before this appeal. Srimati Medalin Nankra Marak, being the direct descendant right from the first registered King Nokma and being the own daughter of late Mene Marak, is the best suitable and rightful successor of the last registered female King Nokma, late Jamse Nankra Marak. I accordingly pass order that Srimati Medalin Nankra Marak, daughter of late Srimati Mene Nankra Marak and late Sri Alipshan Marak, be registered as the successor of female King Aking Nokma of Nankra, 456-15 Aking. Consequently, the illegal entry of late Shura and Marak and her husband Sri Shimrang Momin be deleted from the geological tree of the Nankra Aking Nokma family, my lord. Here is one more thing, my lord. When this case was pending, without giving notice, Shura Nankra Marak was expired, my lord.
Okay.
Subsequently, come into the picture, my lord. Another question is that this Alipson, that is the father of the respondent number 4, since 1976, my lord, till 2000, they are not Nokma, my lord, and they have challenged this order before this honorable High Court, which has been withdrawn. So, question of res judicata is applied here, my lord, or doctrine of oiver is applied, because he is continuous. After his father is supposed to be, but in that case, this Jongshan Momin and his wife Rani Marak was continued, 1978 to 2000. Thereafter, my lord, Shimran and the Shoran and Marak was continued for 3 years. Then another order passed in their favor, so which has been changed here, my lord. So only my humble prayer, that is the disputed question of fact. And moreover, my lord, this respondent number 5, I pray that he is nowhere related to this Nokma. His name may be deleted as a respondent number 5, my lord. I pray that as there is a question of disputed question of fact is relevant, my lord, it may be referred back to the district council for proper adjudication of the matter, my lord. That's all.
Please, Lordship. I am appearing for the private respondent, Lordship. My argument will be first, I will go through my written argument, then I will go to my the affidavit, then
You will be appearing for
private respondent, my lord.
4
This,
and 4 and 5.
Yes, Lordship.
Yes, please.
Lordship, before I begin with the case law, just would like to refresh this court, your Lordship, which I like to rely on the written argument. Actually, this is the fact of the case which I have narrated, your Lordship. If Lordship permitted me, I will just go to the written fact of the case. Thereafter, I'll come to my my affidavit. Then I will counter my learned friend what he has submitted, Lordship. Then. First, your Lordship, as for this, the fact, the very fact of this case is that this one person, Sri Chinang Sama, is the first married. This actually is the original Nokma. He is the first person who has been registered as a Nokma of this case, your Lordship. So what happened is Chinang Sangma first married to Silje and Marak. I am the successor and blood related to Silje. Now what happened, your Lordship? The Silje married to Marak and was the first registered Nokma Ningkra Akeng, and the late Chinang he is having 5 daughters, Lordship, namely Tisi Marak, Jemsi Marak, Mensi Marak, and so and so. And out of these 5 daughters, Jemsi Marak was kept as a custodian to look after the family and parents, and Jemsi got married with Sangrai Sangma. After the death of Silje Marak, a clan people has given Mensi and Marak as substitute wife of Chinang Sangma, but Mensi Marak does not belong to Silje Marak's family. Late Chinang expired in the year of 1938, and after the death of Chinang Sangma and his wife Mensi Marak, the second daughter of Jimsi, and her husband Singrai was registered as Nokma of Nengkra, but Singrai Sangma deserted his wife Jimsi Marak. Therefore, Sri Jongsan was substituted as the wife of Jimsi Sangma, Jimsi Marak. Thereafter, by virtue of marriage of Jongsan and his wife Jimsi Marak were registered as Nokma of Nengkra in the year of 1953, Lordship. 1953, Lordship. Sorry, Lordship. Now, this is a very important, Lordship, that Jimsi died in the year of 1964. After the death of Jimsi Marak, Ringmi was substituted as the wife of Jongsan. Jongsan Momon. However, Ringmi Marak eloped with Margaret Marak
and Jongsan become widower, and 10 years later, Jongsan Moment relinquished. This is the very important which I have put it also, Lordship, in the affidavit, and it is on record also that my written argument is there for your reference. So I'm reading from the para 3, which is very important, Your Lordship, and to that I will substantiate even in the affidavit that the document also has been filed, Your Lordship. So my case is here, Lordship, that after the death, Jongsan Moment relinquished his nokmasip and recommended authorized Alipson Marak and the husband of Mense Marak, who is the third daughter of Chinang Sangma, as the Nokma of Nengkra Akeng in the year of 1973. And accordingly, Alipson Marak and his wife Meni Marak were registered as a Nokma of Nengkra. After relinquishing his Nokmasip and leaving family with Jimsi Marak, and after Alipson Marak and his wife Mini were registered as a Nokma of Nengkra, Sri Jongsan again remarried to Reni Marak, and thereafter, while Alipson and Mini were still functioning and performing as Nokma of Nengkra, Sri Jongsan Moment have again recommended and authorized Sri Simrang Moment and Sora and Marak, and in white order letter 049/1981 to register as Nokma of Nengkra Akeng, and accordingly they were registered as a Nokma of Nengkra. Now, Your Lordship, what happened? Let me just complete. It is the father state. It is father state that Sri Simrang Moment and Sri Sora and Marak well neither belongs from James's bloodline nor having any blood relationship with Jongsan. Therefore, predecessor of the parents, present private respondent, Srimati Matalen Marak and daughter of Alipson and many Marak filed an appeal in the court. None of the daughters and Sri Sora and Marak and Srimati Simrang Moment well claiming for Nokmasip, but Rikmoni and Marak, the daughter of Reni Marak and Jongsan Moment, who have no blood relationship and have no connection with Chenang Sangma and Silje Marak, have been claiming the Nokmasip, which is illegal and not maintainable as per the Gar customary law. Lordship, what I'm trying to do in this submission, first, his claim, actually, in the beginning I said I'm from the first Chenang. From Chenang, the Jongsan is a very vital point. Jongsan Marak was married to my mother. Then after that, he relinquishes Nokma, he eloped and then married to some other woman. Thereafter, he has relinquished. He has even written that I'm no more, don't want to be continue as a Nokma. So he has written the letter to in my favor saying that you will be the as a Nokma. Then after relinquishing, after 10 years, Lordship, he married to some other girl, lady, and he again coming back and claiming that, recommending to the new wife, to that where my learned friend was saying that case is here, Lordship. First, he relinquished as a Nokmasip. He have deserted my family. Then he married second wife illegally, and it is not as per the it was not given by the Mahari. He has taken, and thereafter, after relinquishing her Nokmasip, after giving an appointment to us, he go his own way. He relinquished. He completely left the family of Nokmasip. Once the family Nokmasip is already relinquished, and he has written also, and to that effect, Mojender also is inquiry. I will come to that, Your Lordship, in my affidavit. Then after 10 years of relinquishing, after 10 years deserting and going away with some ladies, he coming back and saying that, he was giving recommendation to his new wife's daughter. So, that is the private respondent, that petitioner. So that is the case, Your Lordship. So that is the whole case. That's the fact of the case, Your Lordship. Now I will go to the affidavit which I have filed, Your Lordship. I will just rely the page 19 of the affidavit.
What is the date of the affidavit?
Date of the affidavit is, this is the affidavit of opposition filed by the respondent. Date of the affidavit, it is 27. filed by private respondent number 4 and 5. Additional affidavit. The phase 20. The date of the affidavit is on 27 June 2017, Lordship.
2017.
Lordship.
17 or 19?
Here it is written 17.
Just a moment. Just a moment. 27?
Yes, 27 June
2017. Yes.
Lordship.
Yes.
So I will directly come to the document, Lordship, which I would like to substantiate this page 19, thereafter subsequently. The statement of Nokma Mahari of Nengkra Akung Lan. Nokma of Nengkra Akung, Sri Jimsi Marak expired. Page 19, Lordship, the affidavit. Page 19, it might have.
This is the English translation.
Lordship.
Okay.
Statement of Nokmas Mahari of Nengkra 456 Brigade 16 Akung Lan. The Nokma of Nengkra Akung Srimati Jimsi Marak expired in the year of 1964, and after her death, we Mahari have arranged Srimati Ringmi Sangma for Sri Jongsan Moman as substitute wife. After 10 years, she eloped with a man from Kasi Hills, and after said elopement, no substitute wife was provided to Sri Jongsan Nokma. For this reason, we released Jongsan Moman. Thereafter, now we would like to include the daughter, sister of Jingmi Marak, real sister, and her husband Alipson as Nokma for Nengkra Akung. All Maharis are unanimously agree to the proposal. Hence, we present the late rear younger sister Mini Marak and her husband Alipson Marak, and all of us Mahari give Nokmasip to her. We for the couple, wife and husband, after due consideration, give Nokma in front of the Majundar in writing, sign and thumb impression. Your Lordship, this is a document where I am saying that actually I am the daughter of this Alipson and the Mini Marak. This is what I have to make a submission, that this Jongsan has relinquished the Nokmasip, and it is on record. It is the Majundar, in front of Majundar. This was in the 1978 compared, and then another Lordship. May I come to is another document, page 25, Lordship. I'll not take much time. I just page 25 of the same affidavit, Lordship.
Yes.
We all of us Mahari willfully give Nokmasip of Nengkra Akung, Sri Mini and Alipson Marak, a man and wife, for registration of Nokmasip Nengkra Akung. So again, Maria has given that I am the daughter of Mini and Alipson, my lord. Then this is very important document which I would like to. May I take you to page 30, my lord? The document, the additional affidavit. Page 30, Lordship.
Page 30.
Lordship. Page 30, Lordship. To the may I just read your Lordship. To the Executive Committee, IC Land and Revenue, Garu Council to Ras subject appointment Nokma of Nengkra Akung Land. KCT so and so. I affair you as forward dated JT so and so. I visited the place, all the Maharis and Jongsan at his home and village, and also on 11/3/1974, Sri Jemsi Marak Nokma of Nengkra died 1964, and after her death, Srimati Ringmi Sama was given to be the substitute wife for Jongsan Nokma. After 10 years eloped to person from Kasi Hills, and because of elopement of Mahari did not give any substitute wife to Jongsan Moman, and all the Mahari discarded him. Sri Jongsan Marak left his work job as Nokma. This is very important. Yes, relinquished. And the sister of deceased Jimsi Marak, Srimati Meni Marak, and her husband Alipson Marak was given all powers of Nokma, and there is no controversy or dispute. The Mahari of Nengkra Akung agree and the disease their sister to be made the Nokma of Nengkra. Akung and they had been given written in writing and put their signature all at the same time. The term impression which by their own act show their willingness to make the couple Simiti Mene Marak and her husband Alipson Marak for inclusion of their name for Nengkra Akung, and I therefore request you to include the name of Sri Mene Marak and Alipson Marak as a Nokma of Nengkra. This is the Majunda report, Your Lordship. How the history of the case it happened. Then I will take you to the annexure, not annexure, page 40 of the same PDP. Page 40. I mean, the type copy and other I'm not going because it will consume paper, but only the relevant point which I feel is very important and will be convenient for the court. Not reading everything, Lordship.
Yes.
Now, Your Lordship, this is the very important. This is the order passed by the CEM, Your Lordship. The Alipson Marak and other, just I will read it. This is the dispute in regards to the succession of Nokmasip of Nengkra. This is a long pending dispute case relating to the succession of Nokma. The declaration of the case in brief is that the husband of Jemse Marak, Nokma of Nengkra Akung died. Jemse Marak Nokma remarried Jongsan Momen by virtue of his marriage with Jemse. Jongsan Momen also become Nokma of Nengkra Akung daughter with a wife Jemse Nokma. In 1964, Jemse Nokma died. The clan people of the disease Nokma supply Ringmi Michik, daughter of Jemse Nokma, from the former husband as a substitute wife of Jongsan Nokma. Jongsan lived together with his new wife Ringmi Michik for 10 years. After 10 years, Ringmi Michik was enticed away by another man from the bosom of Jongsan Nokma. These clan people from Nokma's lineage did not supply another wife to Jongsan Nokma. In the meantime, Jongsan Nokma relinquished Nokmasip in favor of Alipson Marak and his wife Mene Marak. Mene Marak Michik being the sister of the deceased Jemse Nokma as per his Jongsan's written note dated 36/11/1973. The clan people also decided to appoint Alipson Marak and his wife Mene Michik as a Nokma of Nengkra Akung. They approached the district council to appointment of them to have appointment of them. The Majundar was directed to inquire into the matter. He submitted his inquiry report recommending Alipson and his wife Mene Michik for appointment of Nokma of Nengkra Akung. At the time of Majundar's inquiry also, Jongsan Nokma gave another written note relinquishing the Nokmasip in favor of the same person. Afterward, the objection came from the Jongsan Nokma saying that clan people of his decree wife supply substitute wife to him named Rene Michik. This was strongly objected by the clan people, hence the dispute arose. After relinquishment of the Nokmasip, Jongsan Momen marry Rene Marak Michik at his own will. The clan people of Nokma did not give him substitute wife. The woman whom he took as a wife at his own will does not belong to ancestral line of Nokma's family. Jongsan Nokma not only give up the Nokmasip but marry another woman who was not belongs to the ancestor lineage of Nokma's family. So Jongsan Nokma's name should be cancelled from the Nokma register. Jongsan Nokma thus vacated the Nokmasip, and in the vacancy cause, therefore, Alipson Marak and his wife Mene Michik are appointed as Nokma of Nengkra Akunglan with effect from 23/07/1976. Enter their names in the Nokma register, GT so and so, I order so as to the above. Lordship, this order was passed in the 07/1976, Lordship. Since then, this order was neither till today, Lordship. This order has not been set aside, and based on this order, various order has been passed, and this order was repeated in earlier many orders also. It will be there, and they said this order has been not set aside.
So it has not been challenged, so it has attained finality.
Yes, Lordship. It's just attained the formality. Now, I will come to just clarify that, Lordship, that he is stressing mostly on the that alleging that I have registered, I have withdrawn the case. Just that submission of that, I will just come to his additional affidavit filed by my learned friend, additional affidavit by the petitioner, Lordship, where he is to rely that he is accusing me that I have withdrawn and I have no case. All this is then the judgment order dated by the High Court 21/03/2006 has clarified, Lordship. I will just read it, Lordship. Get it.
21.
His additional affidavit, page number.
Date
is 21/03/2006, Lordship.
6.
21. The date of judgment and order.
What is the additional affidavit dated?
That is his additional affidavit dated. Additional affidavit, page 18.
No, just one. The date of the affidavit.
Date. His date is, wait, Lordship.
April 2023.
Lordship.
Oh.
Maybe in the original they may have reflected, but
just
in the copy he has not reflected the date of the. This one month and year is reflected, Lordship.
Yes. So this is 11 April 2023.
Lordship. This is judgment. Just read it. I will read it very fast, Lordship. Actually, if Lordship, I will just read it from para 4. Para 4, the judgment. Para 4.
Just one.
That is page 20, Lordship.
This one. Judgment is at order, page number, page 19.
Page, Lordship, 19, 18. But I will just read it para 4, from para 4, Lordship.
Yes.
Consideration of order dated 17/2/2022 passed by the learned executive member in charge of the District Council Court in favor of the present petitioner would go to show that the eventual conclusion tender in the said order was based on the consideration of the earlier order passed in his regard. That is the order dated 23/07/1976 passed by the learned executive member in charge revenue and appellate order dated 03/03/1978. While revising this said order, the learned chief executive member by his impugned order dated 23/12/2003 has recorded the finding and that it is respondent number 1 in the writ petition, that is the appellant before the chief executive member, who was related by blood to the, I was the appellant in that petition, original Nokma, and in that withdrawal of writ petition. That is what my learned friend was always saying. The withdrawal of the writ petition registered as civil rule number 93936/82 by the predecessor of the respondent number 1 appellant would be no consideration. The learned executive member, while rendering the appellate order dated 23/12/2003, has not indicated the basis on which the conclusion that the present respondent number 1 was direct blood relation of original Nokma has been recorded. The appellate order dated 23/12/2000 does not reflect any consideration of the earlier order passed by the learned executive member, and the and the learned chief executive member 2307-1976 and 0303-1976 respectively. If it is the present petitioner's claim to be the legal heir of Jongsan movement, surely and certainly the aforesaid claim made by the petitioner ought to have been considered by the chief executive member in the light of the concern so and so, in which order claim of Jongsan movement to be recognized as a Nokma has been elaborately dealt with. In any case, there being previous order with regards to the claim dealt with by the appellate order, the dated 23/12/2003, it was incumbent on the affiliate authorities to duly and properly consider the legal effect of the said order, the finding recorded therein, as well as the basis for such finding as indicated in the order in question. The appropriate course of action not having been adopted by the constitutional authority, I am of the view the apparent disseminable impunity have not cryptic the impugn appellate order 23/12/2003, which will call for this court for interference. Accordingly, I interpret so and so passed by the Executive Government Council, and the circumstances of the case noted above, I remand the matter to the executive member for de novo consideration or passing or press order of hearing both the parties, and after taking into account the earlier order so and so. No, your lordship, what happened? This order was remanded, and after that reminding, this was challenged. Then lordship, there is another order, lordship, where they were asked to frame the lordship. May I just take you to the page 68 of the affidavit. Now that was set aside and remanded. Again, they come to the High Court. Now I will just the same affidavit, lordship. In this order, I will not read the entire thing, but I will just only where court has directed page 70.
Page 70.
Yes, lordship. The page 70. Page 70.
Yes.
I am sure in the initiating a fresh inquiry by taking evidence of parties and their witnesses by taking up the following issues will, in my view, finally solve the long pending dispute for Akeng Nokmasip of parties. Whether Jongsan Momo was released from Akeng after Ringmi and Marak decided the Jongsan Moment, whether the clan people actually selected to the Akeng Nokma after Ringmi and Marak decided the Jongsan Moment and left the house of Jimsi, whether documents submitted in GHDC revenue number 35 AC were legally acceptable. Answer to the issue, I sincerely believe, will finally solve the dispute for Akeng Nokmasip. Parties are directed to suggest the issue in adding to the core issue mentioned above, if any, to submit the list of their witnesses, relevant further document, if any. All the steps should be completed immediately by next date to enable to take oral evidence of the parties and their witnesses in view of the High Court's order. Further delays should be avoided to arrive at final settlement. Now, your lordship, this is the very clear what it says. This is thereafter the case has been remanded. Thereafter, lordship, they have now case was remanded back to the GHDC. Then after that, well, my learned friend is challenging the very impugn order. In the impugn order, lordship, if I may take it, all this direction is comply. All this direction was taken into consideration. Lordship is very much aware, and learned senior also will agree with me that there is a principle. There is a till now there people we are following that there is a one judgment laid down in the Dori Sangma in others where lordship is very much aware. Well, it is in the court is reflected very clearly that there should be laid for evidence, framing of issues, taking the examining the document. All those things was directed, and similarly even in this order, lordship, court has categorically mentioned to deal with those four issues, lordship. And in every time, well, the court has been remanding to the GHDC this has been done by the JHTC, the EM and the CM, while trying the matter. They have given an opportunity, and all this evidence has been taken, framing has been framed, and the document has been examined. Even in this very impugn order, Lordship.
You mean to say that the due procedure has been followed?
Followed, definitely, absolutely. And even in the page 143 of the impugn order, Lordship, 146 of the impugn order, Lordship, all this issue has been dealt, and it is reflected. 146 when my learned, yes, the repetition, Lordship. 146, that whether the Sinai Marak, all this frame has been, they have issued 5 issue has been framed. And it was detailed is discussed.
Issues have been framed.
Evidence has been led.
Argument has been heard.
Lordship.
Judgment passed.
Judgment passed. All this. There is nothing illegality in the issue framed by the judgment. Now, my learned friend, he is challenging his order. He has to show that where is the illegality. And time and again, from the High Court, this is the 4 or 5 times coming back to the court. Court has reminded the matter, telling the same thing, that this procedure has to be followed. And each time, when it referred to the JHDC, the frame, all those procedure has been followed. It is not my submission. It is on record. Even in his impugn order, everything is on record, Lordship. That's why my only humble submission, I just say that there is no case made out by the petitioner. This is only to stall the case and to disturb the, because since from 1976, the order which I have enclosed in the disciplinary affidavit is on record, has not been set aside till today, Your Lordship. That is my only humble submission before this court, Your Lordship. My learned senior from JHTC will take a silence, Your Lordship.
May it please the Lordship. Both the sides have heatedly argued the matter, my lord, and placed before this honourable court.
Yes.
But the basic fact which was supposed to be placed has not been placed by both the parties. Our position is very simple, my lord. Matter has come to us under section 8.1 of the Social Customary Act, my lord, and then appeal was filed under section 8.2 of the said act, and we have decided. Accordingly, my lord, they have approached in number of occasions, my lord, both the side has approached this honourable court, and at last, my lord, by the order of retired Justice T.N.K. Singh, he has framed a specific issue which has to be decided by the district council. Now, that issue has been answered in page 154 of the writ petition. But before going to that, my lord, I would like to place this my lord, number of time petitioner and the respondent has read Dore Sangma case. So I will just read the para 20 of the act. I have not given the book list, my lord. I will just read out, my lord. It's already there, my lord. And number of time we have placed the judgment, my lord.
But it has to be on record.
Yeah. Yes, my lord.
Yes, by the time I will charge, it is there. Yeah.
Is the one.
It is there also, that's all.
Para 20, my lord. May I read, my lord, para 20?
Yes.
From all this reason, we will hold that the revenue member alone has jurisdiction to decide a type of dispute at hand. But then, while doing so, the revenue member has to follow the fundamental principle of judicial procedure, this being framing of issues which has been regarded as necessary for the court to get the grip of the case, opportunity to lead evidence on the issues framed, the evidence given could be recorded in full or summary of the same could be noted, and hearing of the parties themselves or through their lawyers, This part, some others accepted principle of sound judicial procedure, like not allowing a document to be used in a case without the other side having been given an opportunity to rebut the same, should also be followed when the case is taken by the revenue member in the first instance or by the chief examiner on appellate stage, my lord. Now, my lord, may you kindly see the orders. There are two orders which has been passed. First order dated 17/2/2020. This order has been passed by the EM. If my lord may kindly come to page 23
23
of the writ petition.
Yes.
So this judgment, para 20, speaks about the guidelines which has to be followed by the trial court, my lord. Now, my lord, page 23, if my lord come to page 23, this is the order of the EM. And my lord may kindly see in page 26, my lord. 26. Para 5, my lord. Following the due process of law, notice was issued to the opposite parties. Both the parties were represented by their lawyers who were heard. So the principle, one principle was followed. The next page, my lord, page 27.
Yes.
Para 7, my lord, says, since framing of issues are a must even in revenue matters such as the present one, and also especially in the light of the ruling of the Honorable Guwahati High Court held in so and so, that which I have read, my lord.
Yes.
The issues was framed, my lord. This order was challenged before the CEM, my lord. The order was set aside by the Honorable High Court, but issues was followed, procedure was laid. Now, my learned friend, who was appearing for the petitioner, my lord, has not said at any point of time that Dore Sangma was not followed. And what is the wrong with the judgment of the EM and CM, my lord? Now, if my lord may kindly come to page 154, my lord. Para 20, my lord.
$154.
152, my lord.
Yes.
Para 20. This case of Aking Nokma dispute of Nenkra so and so Aking traveling a long way from 1973-74 to 2016. As mentioned above in details, the parties also changed originally. Sri Jongsang Momin and his wife so and so filed the original case so and so, registering themselves as Aking Nokma of so and so. It is notice that Sri so and so were also not assisted by any Chra or male members of the so and so, who was the last unregistered female Nokma and on whose dispute arise Sri Jongsang Momin, who was the substituted husband of so and by virtue of his marriage he became the male Aking Nokma of Nongkra Aking. After the death of so and so, who is the only daughter of Jemsi and Marak by her previous husband late so and so, was given to so and so as substituted wife. After living with Jongsang for about 10 years, Sri so and so deserted Jongsang and eloped with one so and so. The Ningkhra clan and the Chra of so and so did not offer another girl to Jongsang Momin as substituted wife after so and so deserted him, and Jongsang Momin was released from Ahim by Ningkhra Chra and clan and Chra of the Aking Nokma family of late so and so. After releasing so and so from Aking Nokma family, according to the custom of Garo, Sri Jongsang, as he has no more right to continue as male Aking Nokma, my lord. That means, my lord, that my learned senior from the petitioner has harp on one side, my lord, the Jongseng. They are claiming the Nokmashi from the side of the Jongseng. Now, Jongseng was not given a substituted wife by the Chra. It is very clear from the record, my lord. So, what right he has, my lord? Now, if I rely on the report which has been submitted after a research, and this book has the authenticity, my lord. This was submitted by the Law Research Institute, Eastern Region, Guwahati High Court. There was a study of Khasi, Jenta and Garo land system, my lord.
Yes.
And this was sponsored by NEC, my lord. And in number of judgments, my lord, this book was referred, my lord. So I'll just read one paragraph of the book. I will give a Xerox, my lord. I will supply a Xerox. At present, I don't have this Xerox. I'll supply a Xerox, my lord. I'll read page 43. It says the position when the mother has no female issues. This is not the case, my lord. Here the female was already there, my lord. If the mother has no female issues, she may adopt a girl as Nokna from her maternal line so that the land does not pass to any other member of a different family group. This is very important, my lord. If a lady dies or still alive, doesn't have a child, a girl specifically, then she has to adopt from her sisters, my lord, so that the property doesn't go out of the Mahari, my lord, or the Chara, my lord. The next point is this, my lord. If the mother died without a female issues and before a Nokna has been appointed, even then the father has no right to select the Nokna. The father has no right whatsoever. On the other hand, the Mahari must provide a new wife to him for the deceased wife family group so that she may have an opportunity to get a female child or to adopt one. Here, this is, if the scenario is this, if the girl died, and Nokma died, she doesn't have a female issue, then the husband should be given a substituted wife. But in his case, my lord, wife has not been given. Not been given. If the mother had female issues but died before she could select the Nokna, then the Mahari must provide a new wife to the widower, as mentioned above. And she could select the Nokna in consultation with the father from among the daughter of the deceased mother living in the house. But if the daughter have meanwhile being married away and living separately, then they have no right to Nokmaship, and the stepmother by select the Nokna from the deceased father family group with the consent of the Chra of the deceased mother. So even if a substituted wife was given, my lord, then she, with the consultation with the Mahari, my lord, has to adopt a daughter from the mother side. That means the first Nokma, my lord. But that is not the case here also.
You're quoting from?
From, my lord, a study of land system of Meghalaya, my lord. Directed by J. N. Das, Law Research Institute, Eastern Region, Guwahati High Court, my lord. And it was sponsored by NEC. I will supply a copy.
You should have given a...
I will supply, my lord. I'm extremely sorry. I will supply. So this is the position of law, my lord.
And what is the relevant portion or page?
Page is 45. Page is 43 and 44 and 45, my lord.
Yes.
And it says also, my lord, the Garo husband by custom comes from a different sub-tribes, Machong, and is not allowed to own the property of his wife. So he cannot own the property. And he, by virtue of getting married by himself, without the clan giving him a wife, my lord, he has no right. And moreover, my lord, what was placed, the facts which was placed, I am not here with the facts of the case, my lord. Only the position I have placed, my lord. Now, if my lord may kindly see the order which is passed by the CEM, that is on page 137, my lord.
Yes.
137, my lord, but I'm reading page 165. That is the last portion. Para 33 and 34. I'll read only page 165, my lord. The successor to the Aking Nokma is through the female lineage and not through the husband or a male Aking Nokma. My lord. Page 165, my lord.
Yes.
Yes. The succession to the Aking Nokmaship is through the female lineage and not through the husband or male Aking Nokma. By not offering substitute wife to late so-and-so, he could not have made his claim for household property acquired during the substitutes of marriage between so-and-so and so-and-so. But Sri Jongsang Momin cannot take along his Nokmaship as if it is some household property, because Aking belongs to the entire clan and the Aking Nokma family is the custodian of the Aking only. Definition of Aking Nokma as defined in the Garo Hills Autonomous District Social Custom and Usage Validity Act 1958, Section 4.8. Nokma means the head of the clan or machong who hold any land as a custodian on behalf of the clan or machong. I therefore consider all the relevant facts, find that Srimati so-and-so is the direct descendant of the late recorded female Nokma, Aking Nokma, that is so-and-so, as her close relation with so-and-so has not been controverted in the earlier proceeding taken up before this instant appeal. Srimati so-and-so being the direct descendant right from the first registered Aking Nokma and being the only daughter of late so-and-so is the best substitute wife and rightful successor of the last registered female Aking Nokma. I accordingly pass order, Srimati so-and-so, daughter of so-and-so, and late so-and-so being registered as the successor of female Aking Nokma of so-and-so Aking. Consequently, the illegally entry of Soran and Nokma and her husband so-and-so be deleted from the genealogical tree of the Ningkra Aking family. My lord. Here, my lord, it is very clear. Once the husband has no claim and no substitute wife was given, and the original Nokma has a daughter, no other person can enter into it. That is the law, my lord. So, my lord, my prayer will be, my lord, that this writ petition may be dismissed, my lord, with cost.
May I please, your lordship? I will make a very short reply on it, my lord. There is neither party has disclosed the matter, even myself also. I have not disclosed. There is two factions, my lord. Two factions, Nangkra clan, same clan, all are from the Nangkra clan only. Two factions are there. Another faction is that when Jongshan Momin, substitute wife, is deserted and going to the West Khasi Hill with another Garo. No, I will
Just
go.
want to say whether my learned senior is pleading, making a submission from the pleading or just from the, he cannot make a submission.
No, it is there. It is there. That is the reason I have filed. Last time I
for the sake of submission, he cannot bring anything.
Yes,
This point was not argued.
No,
this point was not argued. Just a minute. Let us.
Yes.
You have raised something new.
Yes.
We also have the right to answer on this, my lord.
Yes.
My learned senior should have patience.
That is in the pleading.
No. Yes, it is in the pleading. My lord, I am going in short only, my lord. Only
No,
short.
if it is in the pleading, then
No, my lord.
No, it is in the pleading.
If it is in the pleading of the additional affidavit, my lord, whether we have a
Even in the writ petition, my pleading are there.
My lord, my learned senior doesn't allow.
He said in the.
We learned from them, my lord, but he also should have.
But he said even in the repetition it is there.
So I want to.
It is not there, my lord. It is not there. It is not there. Otherwise, you would have.
The fact that there are two factions.
No, my lord. That is.
It is in the pleading. It is not there. Just I verbally, because I have already mentioned that. No, I am coming to
Yes, admitted.
I am admitted. Just I am telling that.
But how can it be? How can you take that into cognizance?
No. There is faction. I am going to that point, my lord. I am going to that point only in short.
If there is a faction, there are if there are two factions.
There's two parties, not faction means two parties from the Nangkra.
There are two parties. Whether that fact has been taken into cognizance, taken note of by the court below, by the CM.
No. I am going to that point, my lord. I am going, yes.
And whether you have raised it at the relevant point of time.
Yes. In the court below it is taken.
No, have you? Just a moment. Let me finish.
5 minutes, my lord. Only 5 minutes.
If it is not relevant, Mr.
No, it is not relevant. I am coming to that point. Then 3/3/1979, my lord. Songshan Momin and Rane Marak filed the case against the order 23/12/1976 of the respondent number 4. Their order was set aside by CM.
Is repeating the same.
No, I am repeating because related.
It's already.
Wait, my lord. They are telling that Garo law, myself also I know, when there is no female in a family, they can take a sister, daughter, just to inherit their property, go through the same line, my lord. That is the Garo custom, my lord. Garo custom, there is, female is the head of the family and husband is the custodian of their property. Even Nokma is custodian of the community land. That one also I know.
That is
no. Yes. Now I am coming 3/3/79, my lord. When their order was cancelled, Rane and the Egyptian woman is there. How they have continued as a Nokma from 79 to 2000, 17, 12, 2000, my lord. How they have continued.
See, that question you have to ask the court below.
No. Yes. Now here, their question, my lord. So it has come in. Later on, 2017, 12, 2000, it has been challenged by the respondent number 4. It has been set aside by this CM on 23rd December 2003. This Medallion Marak has become respondent number 4, become Nukma. After that, there is challenging is there. My learned respondent
When is the
number...
pleading, my lord?
No,
whether it is in the additional affidavit or it is in the writ petition or it is before the trial court. Let them place, my lord, we will keep mum. We are not here to waste the valuable time of this honorable court. If there is no pleading, my lord, my friend has no ground to place, my lord. This is a code of record, my lord. If there is no record, how?
I am never interfere while there are.
Something, my lord, which is
no, my lord.
Last date also, my lord, my learned senior has taken around almost 2 hours, which was beyond my understanding why he have placed those facts.
Because initially they have objected, where is the document? When I go for document, only 2 documents, my lord, 2-3 documents, then they are making halla gulla.
Lordship.
Where is the document, my lord?
Lordship.
In the
what you can... Yes, Mr.
My lord.
What you can do, Mr. Jarika?
Yes, my lord.
Have you filed your written argument?
I have not filed, my lord.
When you file your written argument and list those whatever you have to say, and give a copy to them.
Yes.
If they want to.
We have a serious objection. If it is not before the trial court, my lord, he cannot bring something new, my lord.
Whatever the court will decide on that.
The court will say, and the honorable court is sitting for
Please do.
deciding.
How long will it?
Yes, I will file it.
1 week.
Yes.
Let him file. Take it. Mr. D.
My lord, it's not required. I have submitted my. I am just.
Just give a brief.
I will give a synopsis.
Synopsis. Bullet point.
Yes, madam.
Heard learned counsel for the parties. On conclusion of the hearing, the petitioner has submitted that he may be allowed to file a written argument. The respondent number 4 and 5 has already filed a written argument, and the respondent GHADC is to file a written synopsis of the argument advanced by the learned counsel. On premier, this is matter of 1 week.
No, my lord, 2 weeks, my lord. Next week I am going out, my lord.
2 weeks.
No further
But
time.
do it.
No further time may be
No,
given.
I am
Earlier
asking
also
for
this
the-
matter was already, my lord. He has reopened it.
But how many times they have taken? They are not calculated.
Now you want to go and fight?
Anyway, my
If you want to go and fight outside. That is over.
Item number 14.
Lordship, there will be no more further hearing, Lordship, on this case.
No further.
Lordship, yes. Lordship.
Seventeen.
Lordship, please, Lordship. Lordship, this is the fifth time, Lordship, the petitioners are not here. Lordship, order has flown from this court.
What do we do?
Since April, Lordship, this matter has been lingering without the petitioners being here, Lordships.
The counsel for the respondent.
Number 1.
1 has submitted that the petitioner has failed to be represented in this case in spite of a number of dates given by this court. In fact, this is the fifth consecutive date when this matter was called up that the petitioner has failed to appear. Accordingly, as prayed for, this petition is dismissed for non-prosecution.
Item number 17.
My tanker, which was let out to one Kamal Chaudhary, was seized by police in connection with the NDPS case number 15 of 2019 in 2005 actually.
Yes.
And that tanker was on lease to Kamal Chaudhary by a written lease agreement, and he was plying the tanker, and with that tanker he had loaded ganja in the tanker in a depot in East Jayanti Hills. At that time the tanker was seized. At that time of arrest, this Kamal Chaudhary had shown the original papers which belonged to in my name, but suppressed the agreement with me, the tenancy agreement, the renting agreement. That's how, as an owner of the tanker, I was made accused in the case. I was made an absconder, and then when I got the summons from the court, I appeared in the court and obtained court bail. But I didn't get the chance to produce the agreement and to apprise the court about the situation in the lower court because of the delay caused by death of Kamal Chaudhary. When he died, the court did not proceed for 227 till now, because many years went when all the accused were not present at the same time, so no proceeding could be taken out. Meanwhile, Kamal Chaudhary expired. Some months went in filing his death certificate by his counsel. Thereafter, COVID came. Thereafter only there was a chance. Last year in December, I filed an application under 227 for discharge. The application was rejected by the impugned order, which is why I had come here, my lord.
Mr. Go, so you have come against an, an order of rejecting
yes, my lord.
Discharge. You have come by way of a revision.
Yes, my lord. No, my lord, my ground there also was that in the case record, there is only one self-exculpatory statement given by Kamal Chaudhary, which says I was involved. There is no other documents or no other material on record which says that I am involved in the case. Only the statement of the accused, Kamal Chaudhary, who died. Based on his statement, only absconder notice was issued against me, and I was arraigned as accused in the. My argument is that my point is that based the statement given by Kamal Chaudhary, which is exculpatory, that cannot be used against me as evidence. I rely on the judgment of the Supreme Court on this point. Mark the relevant page, paragraph. That is, it came from Madhya Pradesh High Court. It's Union of India versus Bal Mukund and others respondent.
Mr. Bora, whenever you cite a case, give a proper citation. This is 2009, what is it?
2009 for SBR 56. Supreme Bound Reporter.
Is this a reliable journal?
Yes, my lord. Only circulation is less in Shillong. In other places, it's in, because the books are cheaper than AIR and SCC.
Okay.
My lord, from para 22 gives a I'm reading para 22, my lord. No legal principle has been laid down therein. No reason has been assigned in support of the conclusions arrived at. If a statement made by an accused while responding to a summons issued to him for obtaining information can be applied against a co-accused, Section 30 of the Evidence Act being not applicable, we have not been shown as to under which other provision thereof such a confession would be admissible for making the statement of a co-accused relevant against another co-accused. If an accused makes a confession in terms of the provisions of the Code of Criminal Procedure or otherwise, his confession may be held to be admissible in evidence only in terms of Section 30 of the Evidence Act and not otherwise. If it is merely a statement before any authority, the maker may be bound thereby, but not those who had been implicated therein. If such a legal principle can be culled out, the logical corollary thereof would be that the co-accused would be entitled to cross-examine the accused, as such a statement made by him would be prejudicial to his interest. In the other paragraph, paragraph 36, the court has referred to another case where it was held under para 19 that the confessional statement of a co-accused could not be used as substantive evidence against the co-accused. Now, my lord, if this evidence, the statement of Kamal Chaudhary, is also brought for to be tested in the trial, he cannot be brought to cross-examine him. He is dead. So the court cannot rely on this document to arraign me as a accused in this case. That is my point. Next, my lord, this is reportable in SCC. It's given, I think. I got it from internet. 96 case. It was also referred to by the Rane court below in her judgment also. 1996 9 SCC 766.
1996. This is not. 1996.
1996. SCC 9 SCC 766 page number. Here, my lord.
And this is not the one.
I'm reading.
I think this see, Mr. Bora. Yes. This court time and again has requested the counsel not to, to cite cases, from this Indian Qanun, because more often than not, it's not reliable. Sometimes paragraphing are different.
Yes.
Sometimes wordings may be missing. Yes. It would be safe to go for the recognized journal, SEC, AIR.
They are better actually. They have more in circulation. This is SCC. I got it from the internet actually. It is published in SCC.
You could have. What you do is, before presenting your case, you could have given a list of the
books,
list of dates, list of the books that you are relying on, the authorities, that we can prepare ourselves. We don't expect you to come and bring every book. If you suppose you can't do it, give it to us. We have a library. But going there, sometimes it becomes very difficult when the judgment is prepared.
Lordship, if I may, Lordship, many instances it's happened this way, Lordship. At the time of hearing, they submit a citation before your Lordship, whereas if we are expected to reply to that, Lordship, it is impossible for us to do research and print out a copy immediately, Lordship. Because it's always been advised that the list of books and the list of citations be submitted to the Honorable Court before time, Lordship, even before the court sits.
Yeah, it should be.
That's true.
I think you better do that.
Shall we proceed to another date? Then I'll give you the list and then.
Please do that.
Yes, madam.
How long? 1 week.
1 week. Yes.
Lordship, I'm a bit tied up for the next 2 weeks, Lordship. So, if kindly, with your Lordship's indulgence, after 2 weeks, my Lord.
No objection. Yes.
Much obliged, Lordship.
I'll not make any comment on the proceedings. I'll just say that this matter is adjourned for 2 weeks. In the meantime, please do that.
Yes.
At least file a list of books.
Much obliged, Lordship.
Or pre-made by the petitioner, this is matter after 2 weeks.